Hi, everyone. I'm so glad that you're joining us tonight. We're doing Trees and Georgia Law 2.0. So if you've seen my talk on trees and Georgia law before, you saw the 1.0 version. This new 2.0 version, this is the first time we're doing it. The 1.0 version we really did a deep dive into negligence and duty, standard of care, reasonableness, and a lot of the concepts that go into tree law cases. This 2.0 version of Trees in Georgia Law is just going to examine some cases and the timber theft statutes in Georgia also. I'm just trying to forward this and it's not forwarding. Awesome. Okay, just a little technical difficulty. 1 second. Oh, dear. There we go. All right. So a little bit about me before we get going. I am, as Helen said, I'm a community and urban forester with the Georgia Forestry Commission. I'm an ISA certified arborist. I'm track qualified. And my most recent degree out of just a bunch of them was an MFR from University of Georgia, Cornett, School of Forestry and Natural Resources. I did practice as a lawyer for about 20 years in Florida. I'm still in the Florida bar, but I've taken voluntary inactive status because I'm not practicing law anymore. I'm being an arborist. And so because I'm not practicing law and because I'm licensed in Florida and not Georgia, this is not legal advice. This presentation is informational only. I hope you glean some information from it. These are the topics that we're going to cover today. We're going to go through the kinds of knowledge that courts look for. Actual knowledge. I don't know why it's advancing on its own, but it is. Courts look for actual knowledge. They also look for constructive knowledge. And constructive knowledge is really just a court invention that says you should have known something. We go through the decay standard, which is visible, apparent, and patent decay. That's the standard that the courts invented in 1977 with their first case. We're going to go through that, and they continue to use that standard. Then we go through what I feel are 5 important cases in Georgia about tree law. It's not all the cases that there are, and I intentionally am avoiding anything with municipal liability, although there's one little case about it, but I'm not getting into what a city's liability is in this context. That's a whole different can of worms, so I'm staying away from that. Also, the cases are going to show you that there's a difference in the standards of behavior and the duty that's owed if you're in a rural environment or if you're in an urban one. And then we have a new timber theft statute in Georgia. So I'm going to go through the old one and the new one in tandem together. Now it's kind of just an overview. All right, the knowledge component that I want to go through before we get into the cases is knowledge matters because once someone has knowledge of a tree hazard, then they now have, there's the standard of care kicks in and they've got a duty to fix it. They have to remediate it. So the 2 kinds of knowledge that put someone on notice of a hazardous tree, and once they have notice or knowledge, those terms are really interchangeable in this context. Once they have notice or knowledge, then they've got to fix it. So actual knowledge is what it sounds like. It's when you really know. You actually know because you saw it, or somebody came and knocked on your door and told you about it, or somebody showed you, but you've actually been told or you've actually seen it yourself. Constructive knowledge is kind of a court-invented phrase. It means that you really should have known. And it's when a reasonable person would have known, when you should have seen it because a reasonable person would have seen it. And so the court deems that you should have that knowledge. They're going to say that you have it because you really should have had it. The last standard I'm going to go through before I get to the cases is the standard. It is visible, apparent, and patent. And that is what the I know it keeps advancing. I'm sorry about that. The decay has to be visible, apparent, and patent. And yes, all those words really mean the same thing. Visible, I looked all these up, means noticeable, and both apparent and patent, they both mean obvious. So why just use one word when three will do? So we have this 3-word standard now: visible, apparent, and patent, which just means obvious, really obvious decay. So you're going to see in cases that come up, you'll see over and over that the court uses this test, that the decay has to be visible, apparent, and patent, such that one, and when they're talking about a person here, they're talking about a reasonable person, a lay person, somebody without any kind of expert training or expert knowledge, just a homeowner with no special training. So the decay has to be VAP, such that a reasonable layperson with no knowledge could be aware that high winds might combine with the visible rot and cause damage. And there's a lot of hedge words in that standard. Courts could have said, will be aware, must be aware, shall be aware, but they didn't. They said, could be aware, which really in the legal word, that's a hedge word. And then also that high winds might combine with visible rot and cause damage. That's another hedge word. They could have said that there is a great probability that it's more likely than not that the winds will combine with the damage and with the rot and cause damage. They could have said it has to be a preponderance of the evidence, or more likely than not, but they didn't. They just said might. So it's a real hedgy standard, and it's a little loosey-goosey as far as legal standards go. These are the 5 cases that I'm going to go through, and on the right is what I think that the cases are important for, what they kind of stand for. The earliest case I'm going to go through is Cornett versus AG, and that's the case that came up with this VAP decay test. And it also talks about the fact that there are differences in rural areas and urban areas. And the next case is Willis versus Maloof. I think that one's really interesting because it's the first time that the court had to deal with a boundary tree, and they had to kind of invent the wheel on that one. Then Wade versus Howard, that touches on, and then there also kind of dances away from what's the definition of urban when we're talking about an urban standard being different than a rural standard. Wesleyan College case is really fact heavy, but it's really interesting. All the facts that went into it and how the court says, yeah, you had constructive, you probably even had actual knowledge, but that was up to a jury. And then the last case is a city trying to claim that their poor documentation procedures meant that they couldn't possibly have knowledge, so they couldn't have had a duty to fix this tree or remediate the tree. So you'll see how that goes. So the first case I want to go through is Cornett versus AG. This is from the Georgia Court of Appeals in 1977. The tree here was in Fulton County, and the tree was between 2 house lots. I don't know where specifically in Fulton County, but it was a residential area, and there were 2 houses, bordering each other. They were adjacent. The tree here in question was partially dead. It was 75 to 100 feet tall. It was near the property line, and it was leaning visibly toward the neighbor's yard. So the neighbor came over, knocked on the door and said, hey, that's a dangerous tree. It's aiming right at my shed. You really need to do something about it. Well, the owner didn't do anything about it. And as you can guess, the tree fell. And the experts at trial agreed that the tree failure was caused by the high winds and the visible rot. Here, as I said, the court really had to invent the wheel because they didn't have a standard for deciding cases like this. They went through old texts on civil tort law. They talked about the difference in urban and rural situations and the difference between a naturally planted or a naturally growing tree versus a specific planting of a tree, how there's a different standard there. And the court, for the first time that I ever saw, went through and used the second law of thermodynamics, which said that everything tends toward decay. They concluded that because this is in Fulton County, that this is an urban area. They didn't really discuss it. in detail other than to say that there's a difference between those two settings. And the court said that rural owners, they are not required to inspect to make sure that every tree is safe and won't fall onto a public road. But if the owner has knowledge or finds out that the tree is dangerous, the owner has to take steps to remediate it. An urban owner's duty is just slightly different. The court said that the urban owner's duty of reasonable care does include a safety inspection. And they talked about the difference in a rural setting. You know, a tree falls, it's not necessarily going to fall across a road or hit a target. But in an urban area, there are targets everywhere. And the road is a very likely place the tree would fall, if not on a neighbor or on a structure. But there's a lot of targets in the urban environment. So the standard was different. So here the court said that the owner had been told of the hazard. So that's knowledge. That was actual knowledge. Should have done something about it. He had a duty to inspect once he had that knowledge. Apparently didn't inspect, or if he did inspect, he didn't remediate the damage. The damages here, the money that was given to the neighbor who had told the tree owner to take the tree down, the damages that the court awarded was the difference in the fair market value of the structure, which I think was a shed, the difference in the fair market value before it was destroyed and after it was destroyed. And again, the test used, well, the test that was invented here was this one here, the VAP test. The decay has to be VAP so that one, a reasonable person, a lay person, could be aware that high winds might combine with the visible rot and cause damage. So Cornett versus AG, later cases all refer back to Cornett, and especially this VAP decay test. The next case is Willis versus Maloof, 1987, a little bit more recent. I find this really interesting because it was the first time that a Georgia court had to deal with a boundary tree issue. They had never been presented with this. The facts of this case are that they had a boundary tree. Willis and Maloof had a boundary tree. Willis used to garden extensively around the base of the trunk. He had a big vegetable garden. He saw the tree all the time, and he didn't think it was dangerous. Well, Maloof, the neighbor, he didn't think the tree was necessarily dangerous either until it fell on him and he got injured. He did recover, but he had some medical bills. Well, Maloof sued Willis for negligent maintenance of the tree. Well, the court had never had to deal with a boundary tree issue before, so they said, well, the closest thing we got is the party wall rule. And party walls, if you don't know, it's kind of the illustration on the left where you have two residences or two buildings, and there's a solid wall between them. The party wall rule is what I've got on the screen here, that the adjoining landowners, they each own the part of the wall on their side, but they both have a responsibility to not unreasonably harm the whole wall. And so the court said, we're going to apply that to trees. We're going to say that with a boundary tree, the landowner, they each own the part of the tree that's on their side. They can't unreasonably harm the whole tree. And as you know, there's a lot of things that you can do to roots or branches that could, even though you're operating on your side of the property line, it could unreasonably harm the whole tree. So this was really invented out of whole cloth. Oh, an interesting thing about this is that the neighbors at trial, they were called as witnesses, and they said that the tree didn't look dangerous. It actually had green leaves on it when it fell. So nobody, not the plaintiff, not the defendant, not the neighbors, nobody, there's no indication that this tree was hazardous or that anyone considered it hazardous. Well, Maloof, the guy who was injured, he called an expert, and the expert said that there were 3 visible conditions about this tree that should have put everybody on notice that it was dangerous. The first condition that he saw is that at the base, the trunk curved inward, and to him, that was an indication that the root system of that tree had been impacted from all of Willis's vegetable gardening around the tree. He also said there was a cavity on the tree and that there was fungus growing on the bark. They didn't go into what kind of fungus it was, so I don't know that, but the court said that These three conditions are not enough to alert a layperson that the tree is a hazard. So neither Willis nor Maloof had any actual or constructive knowledge. Maloof did try something really interesting, though. He had medical bills that he was making a claim for. That's why he was suing Willis. He wanted the court to make Willis pay the portion of his medical bills that were equal to the portion of the tree trunk on Willis's property. He was trying to apportion the responsibility and the liability based on the location of the tree trunk. So I guess there must have been more of the trunk on Willis's side than Maloof's side. That was a pretty interesting argument that the court said, no, this is a boundary tree and the duty to maintain it is not apportioned based on the percentage of the trunk that's on your side. So as we all know, tree disease is systemic and it's not confined to one side of an imaginary property line within the middle of the tree. So the court said, good try, but no. And I say bless his heart for trying, because really the worst that the court could do was say no, which is what they did. But that was an interesting approach. The third case is Wade versus Howard. This one touches on the definition of urban under Cornett versus Agee, and then it dances right away from that. Here, there was a 7 to 8 acre undeveloped property off Briarcliff Road in what was unincorporated DeKalb County back in 1998. Well, what happened either during or right after a thunderstorm is a tree fell across the road, across Briarcliff Road, and two people that were in a car at the time, at the wrong time, in the wrong place, they were both killed in that car. The owner of the property was elderly and had not lived on that property for many years, and so obviously had not been there to make a personal inspection of the property. Well, the court referred way back to Cornett versus Agee, and that court's discussion of the urban and the rural standards being different. It said, and I quote, "We assume without deciding that undeveloped acreage in its natural state falls within the Cornett rule because it's in the Atlanta metro area." So it didn't discuss it. It brought it up and acknowledged that we need to decide if this is urban or rural to decide what standard applies here. But they said, well, it's Atlanta metro. We're just going to say it's urban. So they had a chance there to really lay down a definition of urban versus rural in a tree context, but they didn't. The court used the same test again, the VAP test. It said that the decay was apparent in this case, such that one could be aware that high winds might combine with the visible rot and cause damage. Here, strangely enough, the location was inaccessible. It was down an embankment. There were heavy vines and undergrowth at the base. So the injured, the two people that were killed, their family sued, and the court said that the family didn't have enough evidence that that decay would have been visible even if the landowner had been there to make an inspection. The court found that the decay probably was not going to be visible. At least it didn't get any evidence that it was going to be visible. So it said no knowledge, so there's no duty. And the last sentence of the case is in the last sentence of the last footnote of the case. They say what I have quoted up here on the screen, but we need not reach the issue of what constitutes an urban area under Cornett versus Agee. So they realized that they could be laying down the standard and the definition here that we'd still be using today, but they decided not to do that. They just said, nah, we don't have to. We're going to avoid that. So we still don't have a real clear definition other than what we're getting kind of indirectly from these cases. We still don't have a real clear definition. The next case is really fact heavy. This is Wesleyan College versus Weber. It was 1999, so a little bit more recent, also at the Court of Appeals level. The college owned a narrow strip of undeveloped land that was between 441 and a railroad. Well, the whole area was a blighted, overgrown, loblolly heavy area. The school didn't use it for anything. There were no buildings on it. It was just one of those little orphan pieces of property out there. But interestingly enough, the property was right across the street from the college president's home. So the college president, you would think, has to drive past this blighted area pretty frequently because he or she lives right there. Well, everyone agreed. Well, what happened was there was a 94-foot tall loblolly that was 47 feet away from the road. It fell across the road, and the driver of the car that happened upon it was killed. The area was considered by everyone as blighted. There was testimony that there were 15 to 25 leaning trees in that area where the tree had fallen. There were at least 19 dead trees in the area of that fallen tree. The entire canopy was choked with vines and heavy undergrowth. The tree that fell was also down an embankment. There was a 4-foot cavity near the base, but it was covered in vines, and the cavity was facing the railroad side, not the road side. So that meant that if you wanted to go do an inspection, you were going to have to drive over there, park your car on the roadside, walk into and through the blighted area, go down an embankment, find this tree that has vines all over it. They all apparently did. Find the cavity that was facing away from the road, and then make a determination that that cavity might be a hazard. So it's a little bit difficult there. The experts at trial, they agreed that the cavity was 4 feet, a 4-foot cavity. It started 2 feet above the base of the tree. They agreed that the cavity had been there at least 10 or 15 years. They both agreed that root rot was the cause of the failure, but they disagreed on what had caused the root rot. The driver's family said that the cavity did cause the root rot, and so the argument was that they should have seen the cavity. The school should have seen the cavity, and if they saw it, then that would put them on notice that they had a duty to clean this area up and keep it safe. Well, the school's argument was that the cavity did not cause the root rot, and that it wasn't the cavity that caused the problem. So even if they had seen the cavity, they wouldn't have diagnosed or detected that there was a different hazard that was going to bring this tree down. Well, an expert at trial testified that the live crown ratio on this on the fallen tree was 5 to 10%, which you know how low that is. And that was because all the trees in this area were just choked out by vines. The expert determined that the tree from the rings, they studied the rings, and they said that the tree was 35 to 40 years old. It was declining. It was generally unhealthy, and that the rings showed that there had been damage in year 10 that the tree had never recovered from. Then there was a documentable decline 6 years before the fall. When I say that this case is fact heavy, it's got a really interesting twist in it. Before the tree fell, the grounds crew leader for Wesleyan College had gone by that area and had seen there's a whole bunch of dead and leaning trees in this little strip. He reported that to the director of the ground crew. They talked about it, talked about what they needed to do. Yeah, we got to remove these trees, but what's going to be involved if we remove the trees? Well, they determined that they were going to have to stop traffic and block traffic if they removed the trees. So they didn't do it. And I don't know this for sure, but the case kind of reads like, and it implies that they didn't even send anybody out to inspect the area, even though the ground crew leader had reported that this is a bad looking area. So this really is constructive knowledge, if not actual knowledge, because it's being reported and they're discussing it. Well, this turned into a battle of the experts, as they both agreed on the root rot, but they disagreed on the cavity. So the school had the argument that this should not even go to the jury. The court should just dismiss this and say, we win. And it's obvious that we didn't have knowledge. We couldn't see it. It was in that area. It was blighted. It was down an embankment. We didn't see it, and it was covered in vines. So we had no knowledge. So just dismiss the case, call us the winner, and we'll just call it a day. Well, they didn't do that. The court didn't do that. The court said, no, this is going to jury trial. Jury's going to decide this. I'm not dismissing this. Well, the school appealed that up to the Court of Appeals. Well, it took a while to get a decision out of the Court of Appeals. And while they were waiting on that decision from the Court of Appeals, the case below went ahead and went to trial. And they got a big jury verdict against the college. That was put on hold, waiting for this appeal to come out. So when the appeal comes down, the court says that the decision that they're fussing over in this appeal is whether it should have gone to the jury, because the school's saying, just call us the winner and dismiss this case because we didn't have knowledge. Well, the court said that the school has a duty to keep its premises safe, but also the approaches to its premises. So that's the roads approaching to school property. Even though this blighted area didn't have any buildings on it, they still had to keep that approach safe from being a dangerous condition. The school had a duty to make a reasonable inspection of the premises. And the court mentioned the Cornett versus AG rule that although there's no duty to constantly check all trees for non-visible rot, the bad condition of the trees in this whole area should have been readily apparent to a non-expert. And a drive-by inspection, they mentioned, and I bring that up because remember, the president lives right across the street from this and had to drive by it. So the court, in their opinion, they actually said a drive-by inspection would have revealed to a reasonable landowner that this is a problem area. And then once it's a problem area and the owner knows about it, the landowner now has a duty to inspect each tree in that problem area. Court said a reasonable inspection of this area would have revealed that rotten cavity because the cavity was there for 10 or 15 years. So the court said, this appellate decision said, yeah, it correctly went to the jury. And the jury was deciding whether the school had actual or constructive knowledge. And the court pointed out, well, there was a huge jury verdict against the school. So that's pretty much a determination that, yes, the school did have knowledge. Seems to me like very actual knowledge because of the report. I wonder if the court wasn't just being a little polite and saying, well, this is definitely constructive, if not actual knowledge. I don't know, it sounds definitely like actual knowledge to me. So the court talked about liability for the decaying tree, talked about how the decay was visible, apparent, and patent. Said that bad condition should have been apparent to a non-expert. And that drive-by, they're kind of pinning it on the president. But also, I'm sure that the director of the grounds crew got in trouble too. So there's no duty to routinely inspect for non-visible rot, but there is a duty to inspect when you see that visible, apparent, and patent decay and just an overall blighted area, which we've all seen. I'm trying to advance to the next slide. I don't know why. It just sometimes works, sometimes doesn't. Oh, okay. Whoa, wow. Okay, we went really far. Okay, the last case is City of Fitzgerald versus Carruthers. I tried to stay away from municipal cases, but this was one that I liked. So City of Fitzgerald was 2015, which is pretty recent, also at the Georgia Court of Appeals level. Here, it was a city employee, a public works employee. He's standing on city property on the corner of the property. There's two cross streets there, and he gets hit by a falling limb. Well, he recovered. He was okay. Once they got him to the hospital and taken care of, the public works director came out and he testified that he was coming out as a layperson. He didn't have any special training or special knowledge about being an arborist or tree conditions or tree health. So the public works director says, as a layperson, I went over to the scene. I saw rotten limbs at the top of the tree. I saw the overall general decline of the tree, and he ordered removal, but they didn't document it. They did notice, though, and they did note that the cut stump was rotten. Well, the city had no good procedures for inspections. They didn't always document complaints. They didn't always document work orders, and they really didn't even track whether the jobs actually got done. The city said, well, we couldn't possibly have notice because we just don't keep records. So even if somebody told us about it, we didn't really keep the record well, so we don't really know. So they wanted the court, just like the college did, Wesleyan College did, they wanted the court just to say, dismiss this case, call us the winner, and let's just call it a day. We didn't have notice, so we didn't have a duty to do anything. So they did not want that case to go to the jury. Well, the court, of course, disagreed and said, poor documentation doesn't mean that you get off the hook and win the case. Poor documentation means that this goes to the jury to decide whether you had knowledge or not. So let's see, the court said that the rotten limbs at the top that were seen by the director, who saw them as a layperson, and the stump being rotten, and the declining overall state, that those three things indicate at least constructive knowledge, if not also actual knowledge. The jury has to decide whether the decay was visible and apparent and patent, such that the city knew or should have known that the tree was a hazard and they should have removed it. So to me, this indicates that you can't claim ignorance and get out of liability in this. And it kind of surprises me that they tried that, but again, bless their hearts. So we've done our 5 cases. We're going to move into the 2 timber theft statutes now. Georgia has 2 statutes. This first one is the one that we've had for quite a while, and it talks about when there is timber theft or a conversion of timber, then the measure of damages, what the thief has to pay to the owner is, as you see the 4 listed things here, you've got treble just means triple. So triple the fair market value of the trees that were taken. You also get triple of what is now the diminished value of any trees that are still standing, but ones that were incidentally harmed. You get the cost of reasonable reforestation, and you also get attorney's fees and litigation expenses. So it makes it gives a good motive for people to recover in this way from a timber theft or conversion of timber. The law even protects so much to say that if your property is clearly and accurately marked, then somebody comes on and converts your timber, we're going to deem them a willful trespasser because you marked your property. We're going to say they're willful trespasser. And when we do that, that means that you can also get punitive damages from them. Punitive damages are intended to punish someone, and they happen when the conduct is really egregious and really reckless and really bad. So Georgia doesn't fool around with timber theft. This is a really strong statute. And this is really intended to give owners a way to recover when they're in that bad situation of having timber stolen or not paid for the harvest. The second timber theft statute, this is a new one that was just passed last fall. It's a doozy of a statute. It's only 4 sentences long, the entire statute. The first 2 sentences are kind of a mess. It's real hard to parse out what subjects go with what verbs and what phrases modify what other phrases. So rather than show you the statute, this is my simplified version of it. In addition to owing all the things that the timber thief would owe to the owner, as far as the triple fair market value and the reforestation and attorney's fees and all those things, well, other people that hold a security interest in that land, or other people who've bought into it, the timber thief also owes them money too. And the statute protects someone or something, and the something would be a corporation, holding an interest in the land as security for debt. And the statute also protects people who bought into that person or corporation's interest in the land, even if the landowner didn't know about it. The timber thief is going to owe up to the amount of that secured indebtedness to the security holder, plus interest and plus attorney's fees. So this is more punishment for the timber theft. Also, the last portion of the statute says that when there is the timber theft, then there is some timber that's left there, it's either cut and left or it's damaged incidentally from the harvest, then the owner of that property can still use that cut, left, and damaged timber for farm use or for firewood. And even though they're using it, the timber thief still has to pay them for it, even though they're using it. Because that was an argument, is I shouldn't have to pay you for it. Yeah, I damage your trees, but I shouldn't have to pay you for them because you're using it. You're using it for firewood, you're using it to do things around your farm, but that didn't work. So the timber thief owes everybody with an interest in that land for lots of things. This is a summary of the tree law cases that we went through. You can see, or you've seen, how there is a different standard in rural areas versus urban areas, and that's really given the nature of how many targets there are in an urban setting, and how rural settings, you're talking about large acreage, it's harder to notice. You don't always get all the way around and look at all of your trees as frequently as you would in an urban setting. In Georgia, in the urban residential setting, there's no duty to constantly inspect your trees for non-visible decay. And non-visible decay includes, yeah, I've got a tree and it's got a huge cavity in it, but it's covered in vines, and I'm just being lazy and I'm just letting the vines grow and I'm just letting the undergrowth grow. That's okay. It's considered non-visible. You don't have a duty to pull the vines away from every tree or to clear around every tree so that you can see the trunk and the health and whether there's a cavity or not. You don't have to do that. But once you know that an area is a problem, or once you should know that an area is a problem, then you have a duty to inspect the whole area that is a problem. Just like in the Wesleyan College case, that whole area was blighted. Once they find out, or their attention is called to knowing that there's a problem, they have to inspect the whole problem area. And the standard arises, the once you should know, well, that's when the decay is so visible, apparent, and patent that you should know, because a reasonable person would have known. So the court just says, we're going to treat you like you knew because you should have. Also, the last point out of those cases is, if there is visible, apparent, and patent decay, there is a duty to mitigate that hazard. And that's, of course, going to be case specific, whether it's a removal or a pruning or whatever it is to take care of that hazard. But to make it non-dangerous is really the duty. The takeaways that I hope y'all have gotten is that you understand the difference in the knowledge, the types of knowledge that the court requires. They want to see actual knowledge, which is you really knew, or some neighbor knocked on your door and told you that you should know, or constructive knowledge, which is that reasonable person would have known, therefore you should have known, and we're going to treat you like you did know. The VAP standard comes up in all these cases. This is the test that is used in Georgia. Was the decay visible, apparent, and patent, such that one might conclude, or might be aware, could be aware, that high winds might combine with the visible decay and cause damage. We went through 5 what I think are pretty important Georgia case law cases. They showed you the duty to inspect trees and how that's different in an urban setting versus a rural setting. When you have that duty, well, the duty arises when the decay is visible, apparent, and patent. And then we covered the Georgia timber theft statutes, including the new one that gives a whole new category of people that a timber thief will owe to if they are deemed to be the timber thief. We have a lot of time built in for questions. This is my contact information. Feel free to contact me if you have follow-up questions that we are not going to get to, but we are going to do a Q&A, and Brittany, or I say Brittany because I saw that on there, Helen is going to go through the Q&A questions, and we're going to do what we can to answer them in the time that we have.
Great. So first of all, folks, I have dropped the link for the CEUs into the chat. Please let me know if you need me to post it in there again. And now I'm going to go through the questions. We had two versions of the same question, and it's actually a question for Brittany. So I will go ahead and say that we are going to look into this. We had two people ask about Lee's first class, the Trees Law 1.0. So I will ask and see if we still have a recording of that. And if so, I'll see if Brittany can send it out when she sends you a recording of, or when she makes available the recording of this class. Next, let's see. Now we had a question actually that started from before you even started, Lee, and I'm just going to read this, and I think I'm going to mispronounce one of the words. I'll just warn you ahead of time. It says he's checking about the damage valuation methods in Georgia being still, quote, diminution of real estate value, loss to total real estate value for a parcel of land due to loss or damage to a tree, versus replacement value or replacement cost of the actual tree, calculated reasonably during using current tree and landscape appraisal standards of practice. And he says, note, I am a landscape economist by education and training, along with other arboriculture and forestry qualifications. So valuation is a main part of my expert work. Now, this sounds a little bit like what you talked about in the end.
Well, there was one case where the shed was completely destroyed, and the court used fair market value, the difference between the fair market value of the shed as it stood versus the shed destroyed. The plaintiff in that case had wanted to use replacement value of the shed, but the court wouldn't do it. But I think this question is talking more about tree damage or tree removal and valuation of trees. And some of the standards that he cited, gosh, it was kind of a long question, but some of the standards that he cited were there are, as he said, there are standards for appraising a tree. I think that there is more than one group that does that. He mentioned landscape, perhaps architects or real estate. I know that those groups are very involved in appraising trees. Georgia Forestry Commission, my work with the commission, we don't do tree appraisals. We try to direct people to private companies that can do tree appraisals. We stay away from that. So I don't have a lot of information about valuation methods, but I do remember from school that there's more than one valuation method, but I don't know much more than that about it.
Okay, here's another question. And this one came about around when you were discussing Wade versus Howard.
Okay.
Do you think it is wise for a municipality to get involved in boundary tree issues? For example, should the municipality enforce recompense for construction activities that impact a boundary tree, or would it be wiser to leave this as a civil matter?
So if the city is doing construction that impacts a boundary tree, would that be a boundary tree between two neighbors and it's not on city property? It's not on a right of way?
I don't know. If Leighton, if you're available in the chat, let me know and see if you can help me chat in there and see if you can tell me if that's answering your question or not. In the meantime, we'll go ahead and ask another question while we're waiting to hear from you. The next one, it also came about around the time you were discussing Wade versus Howard. And it says tree trunk and root flare are separate, correct? Tree trunk. I'm sorry, I don't have any more information than that, but maybe Mark, you could also explain a little bit about what you meant by that. But is that tree trunk and root flare are separate? Is that?
Well, that hasn't come up. That hasn't been an issue. No one has been fighting over tree trunk versus root flare. Yeah, Wade versus Howard was that's not a boundary tree. That was the Briarcliff Road one.
Oh, I'm sorry. It could have been a case before Wade versus Howard.
Oh, okay. Yeah. Oh, at Willis. Yeah. If it was the boundary tree, they go by the trunk, and the trunk includes the root flare. And so, yeah, different states will treat a tree as a boundary tree depending on the circumstances. There are trees that start off, they plant themselves naturally and they start off right smack on the property line. Those are boundary trees. Then there are ones that grow over the property line. Some states will treat those as boundary trees, some don't. A lot of it can depend on how the neighbors acted, if they acted like it was a boundary tree, or they both maintained it, or if they ever had a conversation about it. Some states will say, no, the owner where it started is the owner forever. So states will treat it in different ways. I haven't ever seen it come down to root flare versus trunk. It's just.
Oh, and I'm sorry, it wasn't root flare versus trunk. It was root flaresis. He's saying was determined in court in DeKalb where I showed the transition. I'm sorry, I'm not getting you, Mark. I apologize. I think I'm just, oh, all right. Yes, participants, I'm sorry. I don't know how to group okay, trunk was separate from the root flare. Sorry, folks.
Is that a question?
I don't know.
Trunks can't be separate from, I'm really not sure what's being asked. I'm sorry.
All righty. Well, let's hop on to another one. Let's see. In an urban setting, if an adjacent landowner's trees are covered in invasives, can you put them on notice that their trees are not inspectable and VAP of any potential decay issues are not detectable and could exist? Would that cover the landowner from a legal perspective? And that came up around the time of Wesleyan versus Weber.
Okay. So urban area, adjacent landowners, I'm going to assume that we're not talking about boundary trees, that we'll be talking about separate trees, but maybe heavily wooded, and your neighbor is just letting the vines go. You're afraid that that's going to mean that they can't do an inspection because the trees are so heavily covered that any defects are not visible. Does that put them on notice? That would put them on. Well, it would put them on notice that their land is becoming unmanageable. It would put them on notice that they may have potential defects that may not be visible because of the overgrowth in the vines. But as far as it sounds like the question is asking, would that put them on notice for liability purposes if a tree falls? That's going to depend on if the complaining neighbor has knowledge of a specific defect. If they go over and knock on the door and say, hey, this one tree, it looks really bad, it's got this huge cavity, you need to do something about that. That's specific, and that was in one of the cases considered actual knowledge. But if they go over and they just try to cover all their bases and say, hey, I'm just letting you know that all your trees kind of look bad and they're covered in vines and you might not be able to see things, that, it's going to be fact specific. It's going to be, well, what eventually did cause the tree to fall? Did it have something to do with how overgrown it was? Or was it something else? So courts probably aren't going to view kind of a blanket notice like that. Think the notice that courts really want to see, that they pay attention to, is a specific, hey, there's a cavity, or hey, it's leaning, or hey, that broke, or something specific that looks hazardous to a layperson. So I don't think that a blanket notice, if I'm understanding the question correctly, is going to be much protection. It'll depend on the facts, though.
Okay. And then this one came about when you were discussing the last law case you mentioned. Would a tree that has been severely taken over by ivy or kudzu be considered VAP decay?
Well, if there is decay, then it would not be visible. If the tree has been overtaken by vines or kudzu, then you're probably not going to see the cavity if there is a decay cavity. If it's really covered, then you're probably not going to see whatever defect it is that, is the problem. So it would not be visible, apparent, and patent if it's hidden by vines. And that I think is one of the interesting things is we can all keep the trees clean. Well, pretty much, especially in an urban setting, we can get the vines off the trees and control the undergrowth. But if we don't, then we're kind of protected. We don't have a duty to pull the vines off and look. We just have a duty to look like a reasonable person should look. And if the vines are hiding the decay pocket, well, then it's not visible.
Okay. Here's another one. So is the definition for use for urban versus rural Atlanta metro as opposed to everything else? So just the counties that are considered metro Atlanta versus the rest of Georgia, or how is that set up?
Yeah, it'd be great if we knew that. That's what the court really danced toward and then danced right away from in Wade versus Howard. They had an opportunity to tell us what is the definition of urban versus rural in this specific tree liability setting. And they said, yeah, we're not going to do that. So all we have is clues based on when they have considered something urban. So Briarcliff Road in unincorporated DeKalb County was considered urban. Fulton County, without any more details, but it was residential, that was considered urban. So all we can do is just look at when they have considered it urban. They could have given us guidance and they didn't. They chose not to.
Okay. All right. And this is a question about timber trespass. Can timber trespass apply for trees removed and converted for firewood and mulch on urban properties, land parcels designated with urban land uses, even if undeveloped?
So someone converts timber, which is theft. So they go onto an urban parcel that's undeveloped and they steal timber or damage timber or cut timber and leave it, whatever. It's still a conversion. Yeah, that's still timber theft.
Okay.
Yeah. I don't know that they would be considered a willful trespasser because in urban areas, we don't really mark properties like out in rural, we see the no trespassing signs, posted occasionally, spaced out evenly along the property line, but we don't do that in urban areas. But there are other indicia of ownership in an urban area, a mailbox or a fence, or, it kind of depends on what indicates that it's owned by somebody. It's an urban area, so it's owned by somebody. So it would be hard to argue that somebody is not a trespasser when it's an urban area. Yeah, so I think, that statute seemed like that it would apply.
Okay.
But again, I can't give legal advice, so I can't apply specific facts to the statute. I can only kind of say, this is what the statute says.
Okay. We had another question. How does the law change for non-laymen? Everyone on this call has varying degrees of knowledge of trees. If the tree injures someone on our property, or are we not considered laymen, and would the courts have no leniency on us because we're professionals?
I have often wondered that myself as I drive around my own neighborhood and see trees. I wonder what my duty is. Do I need to go knock on somebody's door and tell them about there is actually one tree in my neighborhood that concerns me, and I can't figure out what my liability is on that. Arborist personal liability or even corporate liability is a big area of tree law, and I have not researched down that rabbit hole. I have a feeling, just based on what I know about this subject, that they probably would hold us to a higher standard. We're obviously not lay people. We have training, especially if you're a certified arborist or have training in that regard, or you've worked in arboriculture for a while. I don't think you can argue that you're a layperson because we have that knowledge, and we treat people, we look at all the trees we see, we drive down the road and we swerve because we're looking at trees, and we all do it. We can't stop looking at trees. So I think that the court would probably, it's going to be fact specific, of course, depending on what's going on. But yeah, we aren't lay people.
Okay. All right. We actually had two people ask that. So, what is the standard for condition documentation? Verbal, written, photographic? And what would meet the standard for notice? Verbal, a note, certified mail?
There's no rules on that. It just comes up case by case. And the cases that I presented are a pretty good overview of how these situations come up. Boundary trees fall, neighbors knock on doors, and they tell you it doesn't have to be in writing, doesn't have to be by certified letter, but that definitely is the safest way. I have heard a community forester in the city give advice that if they get a lot of neighbor tree concern cases, and what I've heard the advice be is get a certified arborist to come out. They can stand on not the property that they're looking at. They can look over a fence, or they can look over a property line and look at the potentially hazardous tree. If they can make a determination, then they can put that in writing. Homeowner can pay them for it. Homeowner can then send that letter certified to the neighbor with the bad tree. And that is definitely actual notice to the neighbor with the bad tree. It doesn't have to be in writing, but why not cover all your bases and do it safely? Why take chances?
Okay. Here's another one. Do you have any examples of national forestry boundary tree hazard cases? We have a lot of homeowners and landowners who are concerned, especially hazards to structures, fences, and roads.
The first part of that asks about national.
It
Will you
says
read that
national
again?
forestry boundary tree hazard cases.
I didn't do anything national. I kept my research just in Georgia. Doing national cases would be up at the federal level, and I stayed away from the federal level entirely, unless it covered Georgia, but nothing that I wanted to use did. So I haven't done that research. That's just a whole other area of that's federal law, federal tree law.
Okay. We've had a few repeats here. So let's see. Here's another person asking about the urban versus rural definitions. With so much urban sprawl these days, what are the defining characteristics?
We don't know. That's the thing. We don't know.
Okay, let's see. It says for a tree with VAP, and there is a duty to make a tree non-hazardous. Are there further specifications on this to
No.
low risk as defined by ANSI A300 Part 9 tree risk assessment?
No, the ANSI standards are guidance. And no, there's no standard. The duty is to remediate the hazard, which means convert it from a hazard to not a hazard. It's going to depend on the tree and the arborist doing the work as to whether that's a removal or pruning or a reduction or what that is.
Okay. And then is there any case law that assumes tree failure under ideal conditions?
It assumes tree failure under not that I have seen. There's not a lot of tree law. There's just really not. Cases have to make it up to a certain level, which is usually above the trial level, before they're even reported and findable and readable. And while there might be a lot in the trial courts, they either settle, insurance pays it off, doesn't go to trial, and if it goes to trial, it's probably not appealed. So there's just not a lot of discoverable tree law at the level that we can read it at.
Okay. Have courts considered the impact of activity on critical root zone by adjacent landowner, and where liability might then rest if there is a problem?
Well, in the context, if it's a boundary tree, or if it's close to a boundary tree and you're doing something on your side of the property line to the roots, if you really impact the roots and that impacts the tree, I have seen cases where people are held responsible for the value of the tree. There's a weird conflict, and it's not settled law. I've seen it happen different ways, depending on, probably the difference was in different states or different years, that If it's a boundary tree, it's a little different because you have a responsibility. You on your side, but you have a responsibility not to do anything that unreasonably harms the whole tree. So you can't shave off the roots or cut the structural roots. You can't do stuff like that because we all know that's going to harm the tree. If the tree's farther over the property line, it's not a boundary tree, and you're still doing something with the roots to it, there is an argument that the neighbor who owns the tree can potentially sue you or make a claim against you for the value of harming that tree if it really does harm it. A lot of these cases come up when tree roots will reach over and lift someone else's driveway or even mess with the foundation. I've seen them in those contexts, and you really can't harm the tree unreasonably, but you still have the right to do things on your side. So it's not settled. It's not settled law.
Okay. And then this is a follow-up to the ivy kudzu question we had earlier. If the tree is mostly covered with ivy or kudzu, is it not reasonable to consider that the tree will die if the ivy or kudzu is not removed? The tree will be choked out eventually.
Yes. And that to me has seemed really obvious in all these cases, but it never came up in the cases as reported. I'm sure the experts mentioned that in deposition or mentioned that in their testimony at trial. And yes, I agree. And I feel the same way, which is why I think it's kind of odd that there's not a duty to pull the vines off and actually make an inspection, or to keep them vine free, or at least, visible. But if you don't have a duty. It's kind of I couldn't see it. Yeah, I could have tried harder to see it, but I didn't try, so I didn't have to see it. Yeah.
Okay. And believe it or not, we have more questions if you have a few more minutes, Lee.
Okay.
Okay. What is the standard for limbs from a boundary tree?
States differ on this. Some say that any limbs that overhang a neighbor's property, the neighbor can do what they want with those limbs. But again, there's still that you can't unreasonably harm the whole tree doing it. And states just kind of treat this differently. There's no settled rule on it that I know of. And I've not researched this with Georgia. It's just things I've seen come up. I haven't dived into the research deeply, but there's usually the default position of courts in most states is that you can do whatever you want to the part of the tree that's on your property. It only becomes a problem when you do something really severe and that harms the whole tree. Those don't come up that much. If they do come up, they don't really get to the appellate level that we can read a decision about it.
Okay, here's one more. How well do officially prepared tree risk assessments hold up in court? We have performed TRAs on trees with visible decay in the form of cavities and determined them to have a low risk rating, even with constant targets in the potential impact zone.
So how well do the track assessments hold up in court? They will be considered expert testimony. They will probably be submitted into evidence as a professional expert's opinion on the tree. And then they don't come in without the expert also testifying and explaining what all of this entire risk assessment means and how the expert arrived at that opinion based on what he or she saw. And as you know, we take pictures during those assessments, so they'll have pictures, they'll have some backup. I think that we are experts in that regard, and that's a expert prepared report. I think it would be taken very seriously.
Okay. And then the last one, if there is no visible defect, but a property owner notifies their neighbor of a hazardous tree to their property, would the neighbor still be held liable to damage from the branch failure or entire tree failure?
So there's no noticeable defect?
No visible defect, but the
Okay.
property owner notifies the neighbor that it's a hazardous tree.
Based on
It doesn't say. I don't know.
it would depend on what the hazard's based on. If it's just one of those blanket, hey, I'm just covering all my bases, going to give you a letter that says all your trees are dangerous, just in case something happens.
Right.
That's probably not going to work. But if
Okay.
you have a specific reason to put them on notice that there is a specific hazardous condition or, something specific.
Okay, great. Well, that actually wraps up the questions for Lee. Thank you so much, Lee. We really appreciate it.
You're really welcome. Thank you.
All righty. Goodbye.
Bye.